Hello, welcome everybody. Thank you for joining us for today's very much anticipated webinar on breaking down OSHA's vaccine mandate for employers. I am Kim Harding. I'm a partner in Nixon Peabody's Labor and Employment Group in our Rochester, New York office. I'm joined by my colleagues today, my partner Rachel Kahn out of our San Francisco office, as well as Shayla Michaud out of our Providence office, and we are very excited to be here. I'm going to go over just a couple of housekeeping items to start before we begin the presentation and get to what the real action today. I first note that today's call is being recorded. The presentation and the recording will be available and provided following the webinar. Note that you can also send questions to us using the Q&A box at the bottom of your screen. We'll do our best to answer the questions that you sent during the webinar, as well as many of those that you sent prior to the webinar. If you're seeking continuing education credits today, we will announce the code for that during the presentation. Please write down the code. You will need to provide that on your certificate of attendance form in order to receive continuing education credits. If you're experiencing technical difficulties during the webinar, please use the Q&A box to alert us. And finally, for optimal viewing, from the top toolbar, click on View and hide non-video participants. I think that covers the housekeeping. We have a very large group tuning in today. We do have a lot to cover, but just one more thing before we get started, because these webinars really don't happen by themselves. Rachel, Shayla, and I spring them on our team, and they are really the magic behind the scenes that make all of this go on. So please join me in thanking Ramsey from our IT team, Vanessa York, who handles all of your CLE, and our marketing team, including Olivia Cachone, and most importantly, Kristen DeCandia, who is really the wind beneath our wings. You are such an unsung hero and don't get enough credit. So don't send your thanks to us, send your thanks to them, because we couldn't do this without them. So anyway, before, just wanted to make sure that didn't get lost. I'm going to turn it over momentarily to Rachel to get us going. We have three big action items today. Rachel and I will talk to you about OSHA's emergency temporary standard for large employers regarding vaccination or testing. And then Shayla is going to cover the federal contractor mandate pretty much in its entirety. And then we'll follow it up with some Q&A. So thank you again for joining us, Rachel. I turn it over to you.
All right. Thanks so much, Kim, and thank you for everyone for joining today. As Kim mentioned, we're going to kick it off with the much anticipated Fed OSHA ETS for large employers. Just came out, as I'm sure most of you know, very, very recently. So for those of you that are not familiar with the Fed OSHA rulemaking process, I'm sure many of you on the call are not frequently dealing with OSHA, and so this may be your first real entree into the OSHA world. So this, of course, as all of you know, is an emergency temporary standard. So what that means is that it goes through a expedited rulemaking process. It doesn't go through the traditional comment period, notice period that a normal Fed OSHA regulation would normally go through. And once it is published in the Federal Register, it becomes immediately effective upon publication. So when this was published in the Federal Register last week, that's when it became effective. But of course, the actual compliance deadlines are listed in the ETS itself. So although it's effective, it has its own specific compliance deadlines. Because this is an emergency standard, it is only in place for 6 months. That is true of all emergency standards, including the one that was passed this summer, the healthcare ETS. For those of you that are covered by that know that well. And so it also is somewhat of an open question at this point. I know most of us are focused on how to comply with this right now and what is the fate of this ETS moving forward. But a large open question here is, what is Fed OSHA going to do after the ETS, the 6-month period of the ETS has expired? Are they going to put in place a permanent regulation? And that is certainly something that is on the table and that we should be thinking about and considering. And it really will depend if that, permanent standard is OSHA, is COVID specific to all aerosol transmissible diseases. It is yet to be seen, but Fed OSHA is taking comments on its webpage and wants to hear from stakeholders how they feel about this. So when they are making those decisions, they do have that feedback. And some of the areas that we're told that they're specifically focused on is whether or not this should apply to smaller employers, and whether or not the testing piece of this should be dropped and it should just be a straight vaccination mandate. So if you have strong feelings about those issues, how they affect your business, I would encourage you to head over to the Fed OSHA website and provide comment. So, and as many of you that are following this as it makes its way through the courts, a emergency temporary standard is only required to meet the standard of, I shouldn't say only, it's a higher standard of the grave danger standard, that it presents a grave danger to employees. This is versus the significant risk of a traditional typical rulemaking process. So of course, a higher bar, and that is one of the areas that is focused on in the challenges that we have seen already develop, and whether or not Fed OSHA has met that standard. I think historically, Fed OSHA has issued approximately 6 temporary standards throughout its duration, and I think the majority of those have been overturned at one point in the courts. So, so again, it'll be interesting to see how this goes. And of course, COVID is such a unique situation and a unique hazard as opposed to other occupational hazards that we've seen in the past. So, the historical the historics of the other ETSs may not be as telling for the future of this ETS, given how COVID is very different than those other previous hazards. So the challenges that are currently ongoing, there was the race to the 5th district. The challenge in the 5th district got off and running first, and a temporary stay was put in place on Saturday, staying the ETS. Briefing on that was earlier this week, and so we should see some additional rulings there soon. And there's also many other additional challenges that have been filed in several other courts, and that is going to be part of a multi-district litigation. And which district is going to get it is going to depend on a lottery that will be determined next week. But it's obviously very possible that this all goes up to the Supreme Court to decide. So stay tuned. So as an overview, what are the ETS requirements? Implementation of a policy requiring a mandatory vaccination, or a policy that has allows for testing every 7 days or within 7 days of coming to the office, in addition to for those that are not vaccinated. Employers that are covered by this will have to determine employee vaccination status, provide time off and vaccination to recover from side effects, require unvaccinated employees to wear face coverings at all times indoors, require immediate notice for employees to provide immediate notice when of their positive tests, and removal of these employees from the workplace until they meet the return to work criteria. Report OSHA COVID-19 related deaths and hospitalizations. And just a quick note on that one, for those of you that are familiar with the OSHA reporting requirements. OSHA has a requirement that actually, if it's not, if the hospitalization has not occurred within 24 hours of the workplace incident, it's not reportable. And if the death has not occurred within 30 days of the workplace incident, it's not reportable. However, this ETS actually overturns that for the purposes of the ETS. So the traditional rules of reporting are not going to apply. And so just want to make sure, flag that for those of you that are used to the traditional OSHA reporting rules. There's also notice that has to be given to employees of the employer's policies. So the big question, right? How many, counting employees for the purposes of the 100 employee threshold, you know, the ETS itself does not really cover too much how this is handled, but the preamble to the ETS, as well as the FAQs on the Fed OSHA website, which if you have not made it over there to take a look at, you should. The website includes ETS, FAQs, sample template programs, all sorts of helpful items. So certainly encourage you to go over there if you have not done so. So in the preamble, in the FAQs, you'll find this additional information about how an employer may meet this threshold. So it's going to include your full-time employees, part-time employees, temporary or seasonal employees across all locations. It's not going to include independent contractors or employees of other companies working at the same location. Although not necessarily relevant for this regulation, still the multi-employer doctrine is going to apply for any other citations that COVID related, even though they're not your employees. Employer becomes and remains subject to the ETS immediately upon reaching the 100 employee threshold. So that means if at the time of the effective date of this ETS, you have 100 employees, but then let's say you go down to 80, you are still subject to the ETS for the duration of it. Remember, the duration is only 6 months, but you will still continue to be subject to it regardless of the fluctuation. And if you're under, let's say you have 80 employees at the time of it going into effect, but then have 100 employees later on, then again, you need to come into compliance. You'll be subject to the ETS for the duration of the remainder of the ETS. While this isn't in the FAQs, if you head over to the preamble part of the ETS, I call it the preamble, but the part that's before the actual standard itself, it does go into what is considered when a related entity may be considered one company for the purposes of counting 100 employees. And it says that it may be treated, a company may be treated as one employer if they handle safety matters as one company. So one thing to also keep in mind there, if you are a franchisee, staffing agency, you're a host employer that gets employees from a staffing agency, all of that is also addressed in the FAQs. So the FAQ, you know, you certainly have to, according to the ETS, you have to count all of your employees towards the 100 employee count, but the actual requirements of the ETS are not going to apply to those in certain circumstances. So these employees will count towards your 100 employee count, but the actual requirements of the ETS will not apply to them. And those are employees who are working exclusively from home. That means every day, all the time, not employees who come in once a week or every now and then. They must be exclusively working from home. Employees who do not report to the workplace where other employees are present, other individuals are present, and this is going to include coworkers, customers, so people that are really working alone in the workplace. And employees who work exclusively outdoors on all days, do not occupy vehicles with others, and only use indoor spaces for a de minimis amount of time. And then there's also in the FAQs goes into if you're in construction, outdoors does not include if you have, walls up, you're working in an area where there's walls up or there's an overhead that is preventing ventilation of the area. So if you do have employees in the outdoor space, you will want to check that criteria that's in the FAQs. They lay it out more there as well. And then the ETS also excludes certain employers, and those are employers, or I should say certain workplaces, and that's going to include workplaces that are covered by the federal contractor rule, which Shayla will speak to a little bit later, and also settings where employees are exempt under the Fed OSHA healthcare ETS. So those places will be exempt. So make sure that you check those. And even if you're exempt from this and subject to the Fed OSHA ETS for healthcare, the CMS mandate may also come into play for you. So make sure that you do double check that since the Fed OSHA ETS for healthcare does not have a vaccination requirement. So as part of the vaccine or test policy, employers must establish written COVID policies, which must include the following: effective date, coverage and exclusions, requirements for COVID vaccination, information on testing and what those acceptable tests are, face covering requirements, information on collecting and documenting and maintaining documentation, PTO for vaccination purposes, procedures for COVID cases, disciplinary actions, and employers with existing vaccination mandates may keep current policy if all of these ETS requirements are already included. I would encourage you again to go check out the templates that they have on their website. This is one that we see often with employers. That's very easy for Fed OSHA to cite you for if you do not have all of the requirements in your written program. That's a really easy, low-hanging fruit. So you certainly want to make sure that you hit all of the requirements. If you can use their template, I would encourage you to do so because that makes it really easy for them just to go through quickly and double check that you have all of your requirements in place. And acceptable vaccinations. The ETS lays out what is an acceptable vaccination. That wasn't necessarily a surprise. I think what was surprising to many employers as part of this ETS is what would be considered acceptable tests. So the PCR or the antigen tests are acceptable if approved by the FDA, but the antigen test, which is typically, most traditionally the one that you're doing at home, cannot be self-administered or self-read by the employee unless observed by the employer or an authorized telehealth prompter. So that means that if you had employees or you were planning on your employees, taking those at-home tests where you swab yourself and then, you put it in the little tester and it tells you whether or not you're positive or negative, that's not going to be acceptable unless it's observed by somebody else. And, of course, that is can be problematic because those tests tend to be less expensive. And to that point, the ETS does state that employees may be required to pay for the test. So the employer can require that the employee pay for these tests unless another state law or local law directs otherwise. So, we certainly have state laws, for example, here in California, where that may certainly be the case. So you do want to check on those policies. Just because Fed OSHA has said they're not going to cite you if you don't pay for it doesn't mean that you don't have other requirements under state law to provide that. And unvaccinated employees cannot return to the workplace until they receive a negative test result per the ETS. So with that, I am going to give it over to Kim and she's going to walk you through the rest of this.
Thanks, Rachel. I think naturally, to comply with the vaccine or test requirements that Rachel just described, it seems a little bit obvious that you, of course, have to determine the vaccination status of your workforce. OSHA is requiring that you determine the status of every employee, even those that are excluded from the vaccine or test requirements. They want a comprehensive evaluation of every single employee. And OSHA is also requiring that this be an ongoing process. So that requires determining if someone is unvaccinated, partially vaccinated, and or fully vaccinated, and following them throughout their vaccination journey, as we'll call it. So to do this, employers are going to need to not just view, but also maintain copies or proof of vaccination. You can collect scans, email copies. I have a picture of my vaccine card on my phone. That would be fine as long as I emailed that to my employer. And there's also, many states are doing QR codes or I think they're called quick ready codes that employees can kind of scan and show to prove that they're vaccinated. The QR code information is acceptable, but as employers, we need to remember that we have to scan the QR code and then collect all of the information that's provided on the link. A picture or a copy of the code itself is insufficient to meet this requirement. I was somewhat flummoxed by the amount of time that UTS spends talking about QR codes, but I suppose that's just a sign of the times here in 2021. If an employee is entirely unable to obtain a copy of his or her vaccination card because it was lost, stolen, or otherwise damaged, and they've made attempts to secure an alternate copy and failed, they can also submit an attestation under the threat of fines or penalties, stating that they've been vaccinated, provided that it meets a number of specific requirements from OSHA, and that would also constitute proof of vaccination. So we need to collect this from every single employee, and then we need to maintain an employee roster listing the vaccination status. So again, it would indicate the employee name, whether he or she is fully vaccinated, partially vaccinated, excused from a vaccination requirement due to a religious or medical accommodation, or entirely unvaccinated. And again, that has to be for every single employee in the workforce. The roster and the documentation itself are all subject to the confidentiality requirements for medical records. We want to keep those separate from the employee personnel file and not disclose them unless there's an absolute need. However, OSHA is requiring that aggregate data, this roster that has to be maintained, we have to anonymize it and provide aggregate data regarding how many individuals in the workforce are vaccinated as compared to the total workforce population. That has to be turned over within 1 day to any employee or employee representative who requests it. So we want to be very careful to make sure that we are keeping up to date with that process and that we are prepared to turn that over almost at a moment's notice. If you have already surveyed your employees, or you have a sense of who's vaccinated and who's not, OSHA says that is fine. You can rely on those records to date, provided that you actually have written proof or copies of documentation. If you've done an oral survey to say Kim is vaccinated and someone else is not, we need that in writing. These types of proof, again, if you've already done it, are a little bit more relaxed. So perhaps an email that was sent would be fine, anything in writing, as opposed to the stricter documentation requirements that are now required, which would be, like a CDC vaccination card, proof of vaccination from a pharmacy or other healthcare provider, a medical record, a state immunization record, or again, one of the apps or QR codes. Irrespective of whether you've already done the collection previously, you're still subject to the roster requirement. So important to make sure that we're still doing that piece. Hopefully the slide just changed. If not, someone needs to tell me. Okay. Moving on to the next requirement here is paid time off, which was probably not too much of a surprise, but a little bit of an unwelcome one. OSHA is requiring that that employers provide up to 4 hours of paid time off per primary injection. So this is first 2 doses of Pfizer or Moderna, or the first dose of Johnson & Johnson, until we hear otherwise. So 4 hours per primary vaccination. Note that that differs a little bit from some state laws, so we want to be careful on that. The 4 hours for vaccination cannot be offset by other employer-provided paid sick leave or paid time off. This is in addition to what any employee otherwise receives. However, if it's not a bonus 4 hours, it's not an incentive necessarily to get vaccinated, meaning that it only applies if the employee has to take time off or does take time off to get vaccinated. If they get vaccinated, say on a weekend or when they're not scheduled, they're not entitled to be paid for that time. Similarly, employers are not required to reimburse for other expenses that an employee might incur to get vaccinated. And so that is, I'm sure, also good news. Finally, note that OSHA is requiring a reasonable amount of time for employees to get vaccinated, including up to 4 hours of paid time, meaning that if an employee requires more than 4 hours to be vaccinated, in that unlikely circumstance, the employer would be required to provide additional time, provided that it's reasonable. But that additional time would be protected, but unpaid in that instance. The employee could use other paid time off that they may have accrued to cover that if available to them, but we need not cover that time under the OSHA ETS. Similarly, employers are required to provide reasonable paid time off to recover from the side effects. This time off can be offset by employer-provided sick leave, or if you just have a general PTO policy. You can't require an employee to use his, or if you have a sick time policy and a vacation policy, can't require the employee to maybe use their vacation for this purpose to recover from the side effects, but could require that they use accrued sick leave, or again, if you have one general PTO policy, that would be acceptable. If the employee is out of accrued time provided by the employer, we are required to provide additional time in that circumstance. And that additional time means additional time. Can't require an employee to go into the negative, or we can't advance against future sick time that may be accrued. This would be above and in addition. Again, this is a reasonable amount of time. In OSHA, based on the side effects that we've seen in the studies, has estimated that 1 to 2 days is kind of the average. So an employer can cap the amount of time provided to recover from side effects for paid time at 2 days. So helpful, at least, to provide some guidance. Note also that the paid time off requirements that are provided in the ETS are not retroactive. So for employees who have already been vaccinated, if they were not paid for that time or were not required to be paid for that time, doesn't require you to go back in time to figure it out. This is only applying prospectively. Similarly, again, there are various state laws that require pay for vaccination. This operates a little bit independently, so you want to be very careful about managing the interplay between the state law and what we will see should the ETS go forward. Okay, moving right along here. The next requirement is regarding face coverings, and face coverings are required for all unvaccinated employees at all times when they're indoors or when they're occupying a vehicle with another person, except when they're alone in a room with floor-to-ceiling windows or walls and a closed door. That door has to be closed from OSHA's perspective for the person, the unvaccinated person, to remove his or her mask. The employee could also remove the mask for a limited time when they're eating or drinking, or if you have a security checkpoint or something like that, and the employee has to remove the mask for that purpose. Again, very limited in the unvaccinated employee context. Vaccinated employees, OSHA has determined that vaccination is a sufficiently safe mechanism for purposes of the ETS. Note that that's a little bit different from the CDC guidelines, and again, what we see under state laws. So a ton of interplay here and a lot of moving parts that we really want to make sure that we are paying attention to, because compliance with the ETS may not necessarily mean that you're compliant with every state law or what is maybe the best practice for your workplace. For face covering purposes, ETS, it requires at least 2 layers. It also requires that if the face covering becomes soiled, the employee would be required to wear to get a different one. Again, here, good news for employers is that OSHA is not requiring employers to cover the costs of face coverings. They're allowing employees to provide their own and also moving that cost if you want to employees themselves. The ETS, kind of moving right along here, so the ETS does require also that any positive test results be reported by employees promptly to the employer. Promptly meaning either as soon as possible before the employee comes to the workplace, or if they're at work, that means immediately. This requirement of the notification applies to vaccinated and unvaccinated employees. So certainly the unvaccinated employees will be testing weekly, and we may have a better sense of that. But a vaccinated employee is every bit as required to report a positive test result as an unvaccinated employee. And we want to make sure that we're managing that. And again, it doesn't matter if it's part of our testing program or if they got their own diagnostic test or had to be tested to fly or something like that. As soon as they have notice of that positive test, we must require them to inform us. Once we get that notice, that employee has to be removed immediately from the workplace. Again, that's irrespective of whether they are vaccinated or unvaccinated, and they have to remain removed until one of 3 conditions is satisfied. The first is that if they took an antigen test or a rapid test and they got a positive test result, they're able to demonstrate that it was a false positive, we could return them to the workplace. Secondly, they could return if they meet the criteria from the CDC's isolation guidance, meaning that more than 10 days have passed since they first started showing symptoms, their symptoms have improved, and it's been at least 24 hours since they've had fever. Alternatively, if it's a doctor or healthcare provider recommends their return to work, we can rely on that as well. If the employee is required to be removed from work, there is no requirement that we pay them for this time. Again, they may be eligible for sick time or other accrued paid leave, and state paid sick leave laws may apply, but the ETS itself does not require paid time off. Another thing to note here is that the removal program required by the ETS would be just the floor. Employers can provide for a more robust removal program. I know many of you are removing on the basis of an exposure to a known positive, or if you have a cluster, certainly can be more careful and go above and beyond what the law requires or what the ETS requires. But this would be the bare minimum once the ETS takes effect. I'll follow up on Rachel. Rachel touched on this a little bit already, but again, the ETS requires a report for all work-related COVID-19 deaths and hospitalizations. As she mentioned, this reporting requirement differs a little bit from what we typically see with OSHA. Instead of, there is no kind of within 24 hours, or there is no 30-day period anymore. All of those time periods are waived. So as soon as you become aware of a work-related COVID-19 death, you must report that within 8 hours of becoming aware. And similarly, if there's COVID-19 related hospitalization, you must report that within 24 hours of becoming aware. The question here, of course, is what is work related? And this would be a known exposure in the workplace. If you have one employee who tests positive and then the person who sits next to them maybe tests positive the next day, we would need to make a good faith judgment, do a little bit of investigation, look into it to understand based on the facts and circumstances available to us at that time, if it's a work-related exposure. So again, this is regardless of when the exposure occurred. OSHA is taking into consideration the incubation period and kind of what we're seeing for how long it takes symptoms to develop. So we want to look at or make sure that we're reporting as soon as we become aware, again, taking into consideration all the facts and circumstances. As a practical matter, it's often very difficult, I think, as we all know, to know exactly where someone was exposed to the virus or how they got infected. So absent pretty significant proof or a dearth of evidence that it was not work related, we would want to be very careful to make sure that we don't get tripped up on this requirement. The ETS is also very specific to note that if your employee unfortunately has a work-related COVID-19 hospitalization, and then that's followed by a death, that would require 2 separate reports. So we want to make sure that we're getting both of those within the proper time period and understanding that one report will not excuse us from reporting the second. Finally, from my perspective, I think, oh no, I have a couple more here. Sorry, we're still going. The ETS also requires notice to employees, and this is a pretty robust notice requirement, certainly perhaps a little bit more than we see under most notice provisions. So not only are we required to provide a copy of our policy, which should be setting forth the requirements of the ETS and how we specifically are going to implement them, but we also are required to provide to employees the CDC's document titled Key Things to Know About COVID-19 Vaccines. We also have to provide information regarding protections from retaliation and discrimination under the OSHA Act. And similarly, information regarding criminal penalties for providing false statements or documentation also under the OSHA Act. OSHA is very committed to the principle that they cannot maintain safe workplaces, and they are very reliant on the truthfulness of information provided both to employers and to OSHA. So any employee who submits false information, including a false CDC card or any false proof of vaccination, could be subject to fines and a maximum of 5 years in prison if they do that. Likewise, employers who knowingly accept false information could similarly be subject to those fines. So again, want to be very, very careful. Speaking of penalties for non-compliance with the ETS can be up to $13,653 per violation. As you can imagine, that can add up pretty quickly depending on how OSHA considers a per violation, and we expect them to be pretty broad. These violations would be characterized as either serious or other than serious. For deliberate non-compliance, OSHA could issue fines of approximately $136,000. I give up, $136,000. So anyway, a lot to take in here for sure. I'm going to turn it over to Shayla to briefly go over the federal contractor mandate, and then we'll turn back to your questions.
All right, thank you, Kim and Rachel. So that was a lot for to go over. The OSHA ETS is obviously a pretty robust mandate, but it is not the only federal mandate when it comes to employers and vaccines or face coverings. So I'm going to briefly go over how the federal contractor mandate works. As Rachel mentioned, if an employer is subject to the federal contractor mandate, they would not be subject to the ETS, and so therefore this would excuse me, sorry, this would the federal contractor mandate would control. So how does it work? On September 9th, the president issued an executive order which informed federal agencies that they were going to be charged with making sure that federal contractors complied with guidance that was issued by the Safer Federal Workforce Task Force, and that they would need to include in all federal contracts a compliance clause, and that clause would have to flow down to all subcontractors. How is that actually working in practice? What's happening is that agencies are issuing memos or letters, sometimes an invoice type document to contractors that's informing them that they are subject to the Safer Federal Workforce Task Force guidance, or the guidance for short, and they need to comply with its requirements and include the clause in the contract. So the clause will specify that, and the agencies each have basically the same clause, but they do provide the language. It requires that the contractors comply with the guidance and any updates for the duration of the contracts, and that it must flow to all downline subcontracts. The definition of contract is very broad. It's any contract or contract-like instrument between two or more parties that creates an obligation that's enforceable or otherwise recognizable under law. It includes all sorts of contracts, and it does apply to smaller businesses. This one is not limited by employee size. It specifically applies to contracts awarded on or after November 14th, and those awarded before October 15th, where performance is ongoing and an option is exercised or an extension is made. It does not, by its terms, apply to a contract that was awarded before October 15th, but where there's an option has not been exercised or an extension has not been made. So just performance is going on, it's a 10-year contract, but there's been no change to it after October 15th. Then until that extension is made, that contract would just continue. It also does not apply to contracts or subcontracts that are below the simplified acquisition threshold, which is found in the federal acquisition regulations. That is generally $250,000, but there are variations based on certain types of contracts and industries. So you need to check that. And finally, it does not apply to contracts that are solely for the manufacturing or provision of products. So the requirement would flow down until you got to solely to the provision of products, and then that contract would not be subject to the guidance. However, both the order and the guidance state that it is strongly encouraged that this compliance clause be included in all federal contracts. So you may find that federal agencies or prime contractors are requesting that this be included. And then you need to look at the traditional theories of contract and whether or not it can be added, whether there's a clause in the contract that allows it to be added, whether there is a extension or option, or whether it's a new contract and therefore it could be added at that time. But so it is not required, but it is strongly encouraged. This guidance also supersedes all state and local laws and ordinances, and which would make this guidance applicable even where state or local law might state that there can't be a vaccine requirement, for example. But it doesn't exclude noncompliance with other more protective workplace safeties. So as was mentioned by Kim and Rachel, the ETS is the floor, the OSHA ETS is the floor, it's the base requirement. This is the same with this. More can be required than what is required here. Okay, so there are three parts. There's a vaccine requirement, there's a face covering requirement, and there's a requirement to have a COVID-19 protocol coordinator. So for the vaccine mandate, it requires that all US-based employees who are working on or in connection with a federal contract or subcontract be fully vaccinated by January 18th. That date is new. That was changed on Wednesday. The guidance has already been updated effective Wednesday. We got a preview of that from the White House earlier this month, but it's official now. And that was the only change in the November 10th update. This includes everyone in any workplace where an employee is working on or in connection with a covered contract. It also includes remote workers who are working on or in connection with a covered contract. So what's this in connection with language? It means any employees whose duties are necessary for the performance of the covered contract, but may not be working directly on the work of the contract. It can be legal people, it can be billing, it can be HR. It's anyone who is touching the work of the covered contractor. It's a very broad net, and that was the intention of the government. The contractors under this one, you do not have to get a copy of the vaccination card as you do under the ETS. Under this, you just have to view the vaccine documentation, and the documentation requirement is similar to that under the ETS. It's essentially a record of immunization, any official documentation of record of immunizations, the CDC form, a medical record. Those things are all allowed. There's not a specific attestation option, so you do need to see a copy of the record, but it can be an electronic copy, it can be a registry, seeing the webpage, but you don't have to take a copy under the federal contractor guidance. Like under the ETS, contractors need to consider requests for medical or religious exemptions, but anyone who gets an accommodation would be unvaccinated. The accommodation would need to include at least face coverings and distancing requirements as recommended by the CDC. The federal contractor guidance does not have a weekly testing option, and the guidance specifically states that federal contractors can't opt to follow the OSHA ETS in place of the contractor guidance, which means it is a vaccine mandate with no testing option. The next, so what's next? The next requirement is the face covering mandate. Essentially, this is, as expected, all unvaccinated people in a workplace, so those would be those with accommodations, must wear face coverings and maintain social distance while indoors or in any crowded outdoor settings. This federal contractor guidance applies both indoors and outdoors. It does not have an outdoor exception. Fully vaccinated people must also wear face coverings when they're inside a workplace in an area of high or substantial transmission as delineated on the CDC map. So you need to be aware of each workplace that is covered under the federal contractor is a covered workplace, and then know that what the CDC rating is for that particular area. And that determines whether fully vaccinated people need to be wearing the masks. Visitors are also required to comply with published CDC guidance for face coverings and physical distancing in any covered workplace, or you could require proof of vaccination. That is an option, that's a permissible option, but the minimal requirement is that they wear a mask and maintain physical distance. Face coverings must be consistent with the CDC guidance, and notable under that is that masks with valves are not permitted. Face shields without a face mask is not permitted, and masks with a single layer or that allow light to pass through them are not permitted. So they specifically list those as face coverings that are not allowed under the federal contractor guidance. The other question one of the questions that was asked, so going back a slide, sorry, was about boosters. There's currently not a booster requirement under the guidance, but if there is one, they would update the guidance, and then that would be through the compliance clause that would become the requirement for the federal contractors. And the approved vaccines are similar to those under the OSHA. It includes all of the anyone approved by FDA or WHO, World Health Organization. So the traditional ones in the United States are Pfizer, Moderna, and Johnson & Johnson. It would also include AstraZeneca and Novavax, which are approved or in trials in other countries, and those would also be approved. So as soon as anything becomes approved by the FDA or WHO, or certain ones that are in trials, those are also permitted under the federal contractor guidance. And the last thing, the last requirement is that the contractors designate a COVID-19 coordinator. And this person is in charge of maintaining and tracking the workplace safety efforts, and they also must provide the workplace safety protocols and requirements to employees, so that that is communicated out. So it's a slightly less onerous requirement than the ETS. One common question about how this is done, as far as what the federal contractors have to do with the subcontractors. The contractors are required to ensure that the clause is in the contract, the subcontract. then the subcontractor is in charge of making sure that their employees are monitoring and keeping and complying with all the requirements. So the coordinator is responsible for the employees at the covered contractors work only, not with tracking all the contractors, the subcontractors as well. Okay, so that was a pretty quick overview, but one question we know that many of you have is, what should you do next? Employers should, the survey is incredibly important. Obviously, Kim covered this. It's really important so that you understand the vaccination status of every employee, so that you will be in the position to comply with the OSHA requirement. It also helps to look for trends and understand the demographics of who's vaccinated and who's not. You can target education efforts and incentives, both of which have been cited by the White House as things that they would like employers to do in the initial phases in trying to get people vaccinated and trying to reach that goal. They would show evidence of good faith as you try to understand and educate the employees. If employers have current vaccine policies, those current policies may in fact be compliant with the OSHA ETS and or the federal contractor mandate, and they don't need to be changed. If they are, if they have parts that aren't, they might need to be modified, but employers don't have to do a whole scale overhaul if they are compliant. So review any current policies and against the whichever of the two mandates would apply, and then hopefully the hard work's already been done for those. Specific to the federal contractor, for federal contracts, if you have received a memo from a federal agency or a prime contractor, review that memo and to understand what's required and what's not, and also review the contract to find out the date that was awarded. Obviously, you're looking for something before October 15th, whether there's been any extensions or options. What type of contract is it? What is the amount of the contract? To understand if you think that you have contracts that are required to comply with the guidance, and if so, to be prepared for compliance, even if you haven't been notified by the agency or prime contractor yet. And then educate employees. Employees are wondering what's going on. They want to know what is required and what is not. So many employers are sending memos and information out to employees about who is covered, what's required under those under the federal mandates, what are the deadline, what are the exemptions, and what is the status of the different mandates at this time. Those are all things that employers can be doing now to get ready, whether they're need to comply with the federal contractor mandate, or whether we're waiting to see what happens with the ETS and to be prepared in case that ETS does survive appeal and does become effective as it is as stated. Okay, so that kind of covers the federal contractor mandate and the OSHA ETS and where we are now and where things that the employers can be doing. We wanted to make sure to give you your attendance verification code, which is NPCLE 111221, and that is the code that you need to send in for continuing education. And with that, I'm going to kick it back to Kim. Close us out.
Okay, we're going to take a couple more of your questions, if we can. I think we lost Shayla a little bit. So Rachel, one thing a lot of people are asking that we saw a lot beforehand is, how does the issuance of the ETS by Fed OSHA affect employers in states with state OSHA programs?
Yeah, so if you have employees in a state that is a state plan state, meaning it has its own OSHA program, those state plans are required to adopt an emergency temporary standard from Fed OSHA within 30 days, or to tell Fed OSHA why they believe that they already have a rule in place that's at least as effective. While the stay is in place, there's not necessarily that requirement for those plans to do so, but certainly many state plans, such as California, are already in the process of doing that. And I think that you'll see those state plans continue to do that because at any point, if there's a stay lifted, they need to be prepared to have that, to have their ETS in place in 30 days. So I guess there is a potential that you could see some state plans have a ETS in place, even though the Fed mandate may not ultimately be upheld. And of course, as we've been talking about, the Fed ETS is only the floor. So nothing prevents a state plan from making their ETS stricter or having different requirements, different exemptions, different, maybe a state may decide that they think the employer should pay for testing, things of that nature. So if you're in a state plan, you want to make sure that you're really paying attention to what your state is doing, because it could differ potentially significantly from the Fed ETS in terms of being more restrictive.
Awesome. I will piggyback on that a little bit from a New York perspective. We are not a state OSHA state, but we're getting a lot of questions related to the interplay between the ETS and the New York State HERO Act. Currently, we haven't seen any requirements that your HERO plan would require an update in theory. But the HERO Act does require that our HERO Act policies identify all of our administrative controls, and certainly a mandatory vaccination policy or weekly testing option would be something that we're doing to mitigate the potential spread of the virus in the workplace. So long as the designation of COVID-19 as a airborne pathogen and a pandemic state remains in place by the governor, we may see that it will behoove us at the very least to update our HERO Act plans, because there is some interplay, but currently no requirement. Shayla, can you speak a little bit about how federal contractors, what are their requirements to manage compliance downline with their subcontractors? And are they now a police force or doing inspections? What's the requirement?
No, the good news is they don't have to be a police force, because no one wants to be involved in that unless you are a police force. No, what they need to do is make sure that the compliance clause is in any downline contracts. And then once it's in the downline contract, the subcontractors are responsible for managing compliance for their own employees. So they don't have to oversee requirement of the subcontract employees. They don't have to check their vaccination status, et cetera, et cetera. The only time that would change is if their subcontractor came into their covered workplace, then they would have to follow the visitor requirements, or they'd have to, whatever that might be. But as far as the overseeing the employees directly, it's by each employer, not by the overarching, the prime contractor.
So they can basically just assume that they're complying until they learn otherwise.
Right, unless they have objective evidence that would show that they absolutely know that they're not complying. Then that might change. But for the most part, yes, they should be able to assume that everyone is following the rules.
Gosh, I can't wait to get that objective evidence, and then we'll have a real fun time.
Right. Because of course that's subjective.
Yes, it's going to be very interesting. Okay, so hopefully, I think we've covered most of your questions, or we've tried to. We're at 4:01, so we did pretty good on time, but we do remain available. We thank you all for your time. Please do send us your questions. Thank you to Rachel and Shayla for joining us today. To all of you, I hope you have a great afternoon and a wonderful weekend, not thinking about vaccines.